British secret services monitor the internet extensively, and people living outside the UK have so far been unable to defend themselves. But a ruling by the European Court of Human Rights now prohibits this. Because the European Courts of Human Rights, that's the ECTHR, has ruled against Great Britain and its digital surveillance. This means that surveillance without redress mechanisms is unlawful, even if it affects people living outside the UK. Claudio Guarneri, head of Amnesty International Security Lab, and IT researcher Joshua Vida had sued. Both live outside the United Kingdom, so under current British law they had no legal remedy against surveillance by British secret services. The Human Court now says people outside the country have indeed the right to complain. The prerequisite for this is that the invasion of privacy occurs where the communication was intercepted, listened to, searched, or used. The ruling recognizes that it is the UK's responsibility to deal with the two plaintiffs' complaints. Elias Siatista, legal expert at the British civil rights organization Privacy International, says about this, ever-expanding technological capabilities have enabled states to spy far beyond their traditional borders, giving them unprecedented access to people's information and lives. States can no longer assume that digital surveillance will be without consequences or that they can evade accountability by targeting people outside their borders. Guarneri and Vida have not claimed any financial or moral damages. According to the ruling, they said that a public finding of a violation of the European Convention on Human Rights would fairly compensate them. The European Court of Human Rights, the ECTHR, is an international court established in Strasbourg in France by the Council of Europe in 1959. It is based on the European Convention on Human Rights, the ECHR, which is a treaty signed by 47 member states of the Council of Europe. The ECHR guarantees certain fundamental rights and freedoms to individuals, including the right to live, the right to a fair trial, the right to freedom of expression, and the right to privacy. The ECTHR was established to provide a way for individuals to enforce their rights under the ECHR. Individuals can file complaints with the ECTHR if they believe that their rights have been violated by their government, or in this case other governments. The ECTHR can hear complaints from individuals, groups of individuals or non-governmental organizations. If the ECTHR finds that a violation of the ECHR has occurred, it can order the government to take steps to remedy the violation. The ECTHR can also order the government to pay compensation to the victim of the violation. The ECTHR has played an important role in protecting human rights in Europe. It has issued hundreds of judgments that have helped to ensure that governments respect the rights of citizens. The ECTHR's judgments have also had a significant impact on the development of human rights law in Europe. And I have some examples of cases that were heard there. In the case of Hearst versus the United Kingdom, the ECTHR held that the United Kingdom's ban on broadcasting products that were critical of the government violated the right to freedom of expression. And in the case of Pretty versus the United Kingdom, the ECTHR held that the United Kingdom's ban on assisted suicide violated the right to respect for private and family life. And in the case of MSS versus Belgium and Greece, the ECTHR held that Belgium and Greece's failure to investigate allegations of torture and ill treatment of asylum seekers violated the right to prohibition of torture and inhuman or degrading treatment or punishment. The ECTHR has been criticized by some for being too interventionist and for undermining the sovereignty of member states. However, others have defended the ECTHR as a vital safeguard of human rights in Europe. As I said, the legal basis for the European Court of Human Rights is the European Convention on Human Rights. The ECHR is a treaty that was adopted by the Council of Europe in 1950 and entered into force in 1953. It has been signed by 47 member states of the Council of Europe, and all 47 states are also parties of the Convention. The ECHR guarantees certain fundamental rights and freedoms to individuals, including, as I said earlier, the right to life, the right to a fair trial, the right to freedom of expression, and the right to privacy. And the ECTHR was established to provide an enforcing way for those people. The ECTHR is based in Strasbourg in France and is composed of 47 judges, one from each member state of the Council of Europe. The judges are elected by the Parliamentary Assembly of the Council of Europe for a term of 9 years. The ECTHR can hear complaints from individuals, groups of individuals, or non-governmental organizations, as I said, and it is indeed a vital instrument for human rights in Europe. And I once again must say one thing: the Council of Europe has nothing to do with the European Council or the EU. The ECHR has nothing to do with the EU as an institution. The EU is a member of the ECHR, but ECHR is not a part of the EU. So you don't have to be in the EU to be in the European Council, in the Council of Europe, sorry. So that's why there are 47 members and not 27. And because there's a lot of discussion in the UK about this, the UK was one of the driving forces to found this. And the people in the UK should never forget this. And if you want to know something else right now, the next video is right here in the end screen. I'll see you there. I'll be back.